afternoon, everyone, and welcome to the August 8th, 2017 Delaware Public Service Commission meeting. We have the reading of the meeting minutes of July 25th, both the public and executive sessions. Are there any changes, additions to those proposed minutes? And we have a motion to approve.
Motion to approve the minutes of the July 5th meeting and the executive session.
I second it.
Is there any discussion on the motion to approve the July 25th public and executive session minutes? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. On the regular agenda, the matter of the application of Delaware. Oh, that's right. We're better do the consent agenda. Number one, I have one on that one. Sorry about that. Thank you, Commissioner Conaway. We have one item. Anybody want to take it off the consent agenda and put it on the regular agenda? I assume.
Chair, I move that the Commission adopt the consent agenda as submitted.
Second the motion.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you again, Commissioner Conley. She's always keeping me straight. The regular agenda, a matter of the application of Delaware Power and Light Company for approval to revise its natural gas tariff in compliance with new federal regulations regarding excess flow valves. This is our opportunity to get to know more than we'd ever care about excess flow valves. Scott, welcome.
Thank you.
Mr. Nielsen, are you coming forward as well? And Mr. Jerry is coming.
Chair.
Scott, for everybody, I guess, this is coming to us. Everyone has provided their information in a memorandum. So I assume you have some very brief comments to make, and then we can get on with discussing this matter.
I do, Sir Winslow. As you indicated, Delmarva filed
And Chesapeake.
Filed very similar changes to their respective gas tariffs to implement some changes that were made in the federal regulations by PIMSA. The effective date of these changes was April 14th, 2017. And specifically with respect to the issue of excess flow valves, one of the items that PIMSA promulgated was that the utility companies, the gas utility companies, would permit customers who requested an excess flow valve to have an excess flow valve, or they could request one from the utility company so long as they met certain requirements in terms of pressure and that type of thing. So both Chesapeake and Delmarva Power changed their tariffs to basically provide for what PIMSA had set forth in its regulations. And as you indicated, we had several meetings with staff and also with DPA. I think all the parties have filed their comments. I have one additional document. If I could approach and provide that, I would like to do that now.
Do the other parties know what it is?
No, but they've seen it.
Okay.
They
We'll
should
see
be
if
more
there's-
than familiar with it.
We'll see if there's an objection, but please come
It was
forward.
referenced in Delmarva's response. And what I'm providing you with is a copy of the PIMSA final rule.
Is it PIMSA or FIMSA?
PIMSA, however you want to call it. The tab section is the specific section that I was going to refer to, but it is also already addressed in Delmarva's response that was filed on August 3rd. And essentially, the tab section of the final rule sets forth the various comments among the stakeholders in this particular regulatory proceeding and sets forth very specifically what PHMSA's thoughts were in connection with making this particular regulation go into effect. And PHMSA was very clear, I think, in this regulation that they were specifically not mandating that we go back and retrofit all existing gas service lines and put an excess flow valve in place. They indicate in the proceedings that they knew very well that the cost of doing so would be expensive. Not every customer would necessarily be interested in having one, and that they also, in their opinion, felt that it was very likely that the customer would be charged for this installation. So I wanted you to have the benefit of seeing the actual comments that were made by the agency who put these into effect, and that's what led us to basically develop what we did in our tariff provision.
Do we have any objection from any party with respect to the omission of this document?
No objection.
Hearing none, it will be admitted as the applicant on Delaware Power and Light's next exhibit. Mr. O'Brien, I see you down there. Mr. O'Brien, any comments as the applicant? Or who's going to make the comments on your behalf?
Thank you, Chair and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. I'd like to introduce Melissa Koenig, Koenig, who's an engineering manager with Chesapeake Utilities, covering both Delaware and Maryland. Yes, we are in the same boat as Delmarva Power. We did file back at the end of March an application seeking the tariff change based on language that Delmarva had already filed. And then at the beginning of August, we also filed comments after meeting with staff and DPA and reading their comments. Just real briefly, in our August 1st comments, we identified the three areas of disagreement between the parties here. And one of them being whether we were permitted to put a sentence at the end of our tariff stating that the company does not guarantee or warrant the operation of the EFV. Both Delmarva and Chesapeake had that statement in there. Neither staff nor the public advocate agreed with that. For purposes of compromise and coming to an agreement, at least with the public advocate, we did drop that request. A second point of contention was whether or not, if we were going to charge customers for the installations, whether or not we would charge an estimated installation cost like we do for contributions to native construction or CIACs, and move forward from there like that, or whether we would have to true up the estimated costs. Again, for purposes of agreement with the public advocate, we went ahead and dropped that request and decided that it was fine that we would true them up, but really only if we did get the third point in our favor, being that customers needed to pay for the installations. Because that one point, if we did have a multitude of requests, it becomes that much more difficult to track the costs and go back to customers and get them to pay the difference if it was underestimated. The third point of contention is the one that we're probably going to spend the most time on today, and that is whether or not the customer pays the installation cost or whether the company pays the cost and just rolls it into their rate base. As Delmarva Power pointed out, PHMSA themselves, in their comments with the rulemaking, certainly included in their analysis their expectation that customers would be paying for this. In fact, if I could just read a couple of quotes from the PHMSA rulemaking that Delmarva did just introduce into the record, and we did cite this in our comments also, at least in the comments from the Maryland Commission that we included with our comments. Okay, PHMSA understands that the cost of installing an EFV on an existing line at the customer's request is more expensive than if the line were new or being replaced due to excavation and additional labor costs. And PHMSA determined it was not cost effective to require the fitting of an EFV on all existing services. Skipping down a little bit. Further, it is PHMSA's understanding that customers would typically be required to pay for these installations. From an economic standpoint, an EFV requested and paid for by a customer would actually increase the overall net benefit of the rule, as PHMSA can infer from the customer's choice that they value the EFV's protection at a level greater than the cost they pay. Clearly, PHMSA's looking at this as a situation where appropriate price signals would lead to a more efficient use of resources. That's economics 101. So if you provide something that's free that actually has a cost to it, then the outcome from that could be skewed. Another thing we'd like to point out is that right now there's no evidence in the record, or we've found no surveys to the effect of how many people are going to request the EFV if it is free. We've got a survey that staff referred to that PHMSA provided a number for, but that apparently was for when people needed to pay the installation costs. So we don't know how many people are going to request these things if they're free. Now, just real quickly, in our other jurisdictions, I understand the public advocate may have comments referring to other jurisdictions. And like I said before, we have now joined an agreement with the public advocate on what their recommendations are. But as you probably know, Chesapeake Utilities has divisions in Florida and in Maryland. In Florida, the PSC has decided to require customers to pay the full installation costs there. In Maryland, they've made the same decision with one caveat. They are having customers pay the cost of the materials themselves, which is a very small percentage of the entire cost, because it's the installation and restoration that makes up most of the cost of the EFV installation. In Maryland, they do the same. In fact, we applied at Maryland for language similar to what we applied for in Delaware. Maryland staff has issued comments supporting what we filed, which is actually all three of the disputed points in Chesapeake's favor. They support that. We're going before the commission tomorrow morning in Baltimore for that proceeding. We certainly expect that it's going to go through as requested because staff supports it and the Office of Public Counsel over there has no objections to it. We can certainly let staff and DPA know how that turns out tomorrow, but that's where we are with our other jurisdictions.
Thank you, Mr. O'Brien. Mr. Willard? Mr. Willard.
Yes, Your Honor, as been indicated, there's no agreement on this from staff. I'm not sure, Mr. O'Brien said that they agree also about the true-ups, and I'm not sure what DP&L's position is on whether they agreed with the true-ups.
We indicated in our filed position that I filed on August 3rd that we agreed with DPA's position on it.
All right. As far as the staff is concerned, again, PHMSA requires that you tell everybody about the availability. Staff feels very strongly that this is a safety issue, that an EFV can actually save lives and be a very strong safety feature. And utilities in Delaware, the commission is supposed to regulate a utility so that it provides safe and adequate electricity to its customers. Well, if you're going to provide safe electricity, you should have an EFV if it does provide safety, which I don't think anyone can disagree with.
Yes.
I'm sorry. Yes, I'll be all right. Again, my understanding stand to be corrected here, but I think Delmarva estimated $1,800 as the estimated cost, and Chesapeake estimated $2,850. Well, now they say they're going to do the actual cost and true it up, so that's not there any longer. Again, I know the public advocate also agrees that the cost should be borne by those asking for it and not by everybody. The staff feels this is basically an expense that the company should bear, and everyone should have an EFV if they want it. And if everyone has it, whoever asks for it will get it, and the cost of that will just be in the next rate case. Again, as they said, the surveys indicated that very few people were going to ask for this. Now, that's with a cost attached. If it's free, nobody knows how many people will ask. But we don't think it's really smart to assume that everybody's going to get this. Because in order to get this, you're probably going to have your yard torn up or your driveway torn up or something to have it put in. A lot of people aren't going to bother with that, and they're going to get the notice that says you're allowed to get this, and they're going to put it aside and not ask for it. So nobody really knows how many people this will be. And as we said, staff strongly feels that this is a strong safety issue. Again, the National Transportation Safety Board has been recommending installations of EFVs since 1971. It really is a safety feature that should be out there. And while
Don't they recommend safety features, but doesn't the PHMSA then do a benefit cost analysis and do a lot of other, stakeholders coming in, experts, the standards people coming in? I mean, it's not just, I understand there's a safety issue, but you don't implement every safety factor that might be applicable to a car or to a toaster or to a gas pipeline, right?
Yeah, I understand that.
So you're saying that it's so dangerous that those people who are requesting the EFV should be protected from this danger, but the people not requesting it shouldn't have the same safety factor?
Well, I think everyone should have it, and apparently someday everyone will, because when their system gives out, they will get it for free. If it's a new system, they'll get it for free.
Well, it'll be put in the rate base, not going to get it for free.
I'm sorry. Yeah, they won't have to pay for it at the time of installation. And also, again, the staff feels if you have to pay for it, who's going to get it? People with money will get it, possibly. They may not, but they might. But if you're a poor person, and they're talking thousands of dollars possibly, very few, if any, poor people are going to get this. And the staff feels that's kind of discriminatory. The poor people aren't going to have the safety features that other people can afford to have. And the staff just feels everyone should be as safe as the next person, and everyone should have this if they want it.
Well, couldn't staff, make an application and ask that everyone get an EFV, that everyone have the opportunity to have their driveway torn up so they'll be that much safer?
I suppose that's possible, Mr. Chair. Again, the staff also understands if the commission doesn't agree to this on staff's point of view, again, they would think it would be best to establish a set price, which I'm not sure if the companies are prepared to do that at this point or not, instead of this estimate that's going to change depending on when it's done, et cetera. Or, again, another provision that the staff suggested and was rejected, I understand, by the companies was that maybe just a flat, small fee of $100 to $300. And that would maybe prevent people from just saying, oh, this is free, let me have it. But also be low enough that if you're not that wealthy, you still might say, hey, for the safety, I'm willing to do that much. So the staff feels either set a low fee like that or no fee at all, or at least set an established price that everybody knows going in ahead of time. And they may have already been prepared to do that. I'm not sure about that.
From Delmarva and from Chesapeake, why can't you do it like PICO did it in Pennsylvania?
PICO is getting, the customer is paying for it in PICO.
Right, but they're not truing up afterwards, right?
That was our original proposal. And to attempt to work a compromise, we agreed with EPA's concern about the true-up. But our original proposal did not involve a true-up. Original proposal is we give them an estimate of what we think it's going to cost, the best estimate we can come up with at the time, and then after the work is completed, if it ends up costing, it is what it is.
But my understanding was your original proposal, you wanted to put, if it was more expensive than estimated, you wanted to put that in rate base. And PICO's tariff, they give a contractual price to the homeowner, and there's nothing in rate base. It's all done. It's installed. It doesn't go in, nothing. No excess goes into rate base. There's there's nothing to be returned to the customer because there's been a contract price.
I think we would be willing to agree to doing that. Because originally what we talked about was approximately an $1,800 or $2,000 cost. I'm sorry, I'm looking to Bob Kitson, who was with our gas division.
Yeah, we would hope as time goes on, maybe the cost would come down.
Yeah, as we got better at it, use different technologies, that type of thing. But obviously, our concern is if you're we have 77,000 customers that are technically eligible for this, and if we don't know how many people are going to ask for it. At the moment, we've put notice on the website. We have still not individually notified customers because we wanted to know what the outcome of this proceeding is so we can give them the full, okay, if you want it, this is what's going to happen. So there's a potential that there could be quite a few people that ask for it. We just don't know.
Mr. Wood, I apologize. You have some further comments?
Again, I think we're all in agreement now about the line they wanted to put in their tariff that said we don't guarantee this because it's not our product. I think everybody's agreeing now that that'll come out. And again, we do have Mr. Nielsen here and Mr. Platt. If there's any questions that can be answered.
I think we're beyond the evidence taking place. All memorandum have been placed before the commission for decision. Mr. Drew Slater, please, public advocate.
Good afternoon, Mr. Chair and Commissioners. Thank you for the opportunity to share our thoughts on this issue. We agree with Chesapeake and Delmarva. They've both agreed to accept the DPA's EFV cost recovery proposal. And we're speaking here today because staff obviously has not accepted that proposal. Staff's addendum to its original memo posits 4 issues. First is an EFV as safety device. If you read only staff's addendum, you would think that the DPA, Delmarva, and Chesapeake are contending that the EFV is not a safety device, but you would be mistaken. We all agree that EFVs provide greater safety in the event of a ruptured gas line, an event which might occur during excavation. The second issue is who's responsible for gas safety, and the DPA agrees that this commission has a responsibility for pipeline safety. But so does PHMSA, and PHMSA concluded that it's not necessary to install EFVs on all existing lines. PHMSA has required EFVs on new installation and replaced service lines since 2010. If PHMSA thought every existing line required EFVs, it would have implemented a regulation mandating EFVs installed on every service line, new, replaced, or existing back in 2010. It did not do that then, and it didn't do it this time either. It only mandates installation under certain circumstances, as you've heard from Delmarva and Chesapeake. Staff attached a 1996 NTSB article that called for installing EFVs on new and replaced distribution service lines, which is what PHMSA now requires. However, the article says nothing about retrofitting all existing service lines with EFVs, which is staff's position. And as we pointed out in our comments, the NTSB also submitted comments into the PHMSA rulemaking that resulted in the amendment that led to these dockets. And there's no indication that the NTSB contended that all existing service lines should be retrofitted with EFVs. If you only read staff's addendum to its original memo, you'd think that neither Delmarva nor Chesapeake is currently providing safe, adequate, or proper service because it hasn't installed an EFV on every service line that does not yet have them, but you would be wrong. Staff's addendum, in my opinion, is recklessly instituting fear with the perception that customers without EFVs are in imminent danger. Further, staff insinuates that the DPA, Delmarva Power, and Chesapeake Utilities don't care about customers, private property, and loss of life. This couldn't be farther from the truth. Life is precious and priceless. We're not suggesting that customers should not be safe. If staff believed customer safety was in peril, it would have long ago suggested that all EFV installations be free and installed immediately, and would have asked this commission to penalize the companies for providing unsafe, unreliable service to customers. And if the commission thought that Delmarva and Chesapeake were not providing safe, adequate, and proper service because they were not installing EFVs on every service line, wouldn't it have already so found? The sky's not falling, thanks to Miss Utility staff's pipeline safety team, Delmarva Power, and Chesapeake Utilities. Collectively, they do tremendous work to prevent underground facilities, including natural gas lines, from being struck in the first place. The third issue raised by staff's addendum is what options should be considered, and its final issue is who should pay for gas system safety, which is really the crux of the issue here. We believe that these issues really are one and the same, and here are the options. You can socialize the cost of installation across all customers. That's the approach that Rhode Island adopted and what staff is suggesting. A second option is that customers requesting an EFV pay some amount, $100, $300, $500, and the rest of the installation costs would be borne by other ratepayers, and this is staff's fallback option. You have the DPA's proposal, which is that customers pay all costs over and above the cost of the EFV itself. That's the approach that Maryland adopted, and it's the approach that the DPA and both Chesapeake and Delmarva support. And you have what some other commissions have approved, which is that the requesting customer pay for all of the installation costs. That's the approach that Pennsylvania and Florida have adopted. If you calculate how much would go into the rate base or be recovered via surcharge, if every customer eligible requested an EFE, it would be potentially hundreds of millions of dollars, according to Delmarva and Chesapeake's letters of support for our position. Staff further castigates the DPA for incorrectly calculating what the cost would be to Delmarva and Chesapeake customers if everyone eligible for an EFE requested one. Staff statement saying that our numbers are actually too low simply proves our point. It will cost the companies potentially, millions and millions of dollars to install EFEs on all existing service lines. Our cost estimates may have been too low, but even the low estimates for customer impacts are compelling, especially given the cost of the Bloom and the RPS charges to consumers. Staff says that what other commissions have done is irrelevant, but it's actually not irrelevant. For example, in the most recent Artesian case, this commission asked staff to investigate what other commissions do with respect to allowing a party in a contested evidentiary hearing to substitute one witness for another that submitted pre-file testimony. Specifically, directing staff to investigate and report back as to whether other states, such as Maryland, New Jersey, and Pennsylvania, have guidelines or processes, rules that address substitution of witnesses. In docket 09414, it examined what the Maryland and District of Columbia commissions had done with respect to Delmarva's request to amortize its 2008 pension losses. The DPA admits that this proposal discriminates between new and old customers, but that's the policy decision that PHMSA set back in 2010. The Commission has approved an expansion area rate for Chesapeake so that existing customers don't foot the bill for the addition of new customers. This situation is akin to an expansion rate. Further, staff's proposal is discriminatory too. It discriminates against all customers who do not request an EFE, but will still be paying for some who do request one. So should low-income customers subsidize affluent customers, and should renters then subsidize homeowners because renters have no say? Such subsidization would occur under staff's proposal. And finally, the DPA made a few arguments that staff ignored, but we think they're important to reiterate. First, there's been very few reportable pipeline incidents in Delaware over the last 20 years, and we want to commend the work of this utility and staff's pipeline safety team and Delmarva Power and Chesapeake Utilities. Delmarva and Chesapeake reported that hundreds of lines have been hit over the past several years. Delmarva says about a third of those hits had an EFE installed, but it didn't have information about the damage to persons or property readily available. The same is true with Chesapeake, where no personal injury or property damage have resulted from the service lines being hit. Second, staff doesn't address the DPA's argument that EFEs will not protect against all gas leaks. It's not designed to close if a leak occurs beyond the meter or house piping or appliances, and it will not close if the leak on service line is small. Third, staff does not address the DPA's argument that free EFE installation could soon overwhelm the utilities. Fourth, staff does not address the DPA's argument that free installation gives customers the incorrect impression that they're an impending risk unless an EFE is installed. Moreover, taking staff's argument to its logical conclusion, if customers without EFEs are at greater risk, then Delmarva and Chesapeake are not providing safe, adequate, and reliable service, and they should be penalized. The DPA rejects that idea that they're not providing safe, adequate, and proper service simply because an EFE is not installed on an existing line, and we believe the Commission should reject that idea as well. Fifth, I swear I'm getting there. The staff does not address the DPA's argument that free installation would give customers no incentive to consider costs because other customers would be helping to pay for it. In fact, staff's alternative proposal of having the customer pay some relative small amount actually makes low-income customers worse off than if an installation were to be socialized, because $100 or $300 or $500 is unlikely to deter an affluent customer, but for those living paycheck to paycheck, could be a significant amount. So in conclusion, Maryland, Pennsylvania, New Jersey, New York, Virginia, and Florida all require the customer requesting an EFE to pay for its installation costs. Staff points out Rhode Island not for its comparable size to Delaware, but because that's the closest state that agrees with their position. Staff's proposal would have you believe that customers are facing impending danger and that all costs, many, many millions, should be socialized across all ratepayers. The DPA believes prevention is the ultimate goal, and we should continue to provide any assistance we can in helping educate contractors and consumers to prevent damage to underground facilities. We've promoted Dig Safe Month through social media. We provide a link to 811 on our website, and we'd be happy to participate with staff and the utilities in outreach programs to educate individuals and contractors on the importance of damage prevention. The DPA would like to thank the Commission for their consideration and again acknowledge all the hard work from this utilities, staff's pipeline safety team, Delmarva Power, and Chesapeake Utilities. Thank you.
Thank you, Mr. Slater.
May I briefly respond?
You going to say something in rebuttal?
Yeah, just very, very quickly. Again, Mr. Slater talked about what our addendum did and did not do, et cetera. Again, I just want to make sure, I don't think any of us are trying to say that they do not provide safe service. We're just saying this could be even safer if the EFD were installed. So to say that we're saying that they don't provide safe service, we don't agree with that. We're also not trying to scare customers. By telling customers that this is available, we don't think that's telling them, you really better get this, or, we're not saying that. Again, other states do things differently. They're other states. So we shouldn't necessarily do what other states do. Again, we certainly did not mean to insinuate that anybody didn't care about life or safety. We're just saying things could be better, even more safe. All right, and our understanding is people have known about this now for several months. They're already being told that this is available. And nothing about cost has been said, or maybe they've been told you have to pay for it. But in any event, we understand there hasn't even been a question raised about it yet. Not only hasn't anyone asked for it, but nobody's even asked a question about it. So we're not sure how many people are really going to be interested in this.
And we're not going to speculate about that either.
Okay.
Well, is that all the comments around the table? Speaking for myself, I feel pretty strongly that we have gone through a merger process, and for good, bad, or indifferent, we have now tied ourselves to a few other states who have the same parent company, and that it behooves us, and it's to our favor if we see things where we can be consistent with other states, where efficiencies can be gained, where cost savings can be given to all classes of customers of our utilities, that where there can be consistency across jurisdictions. That's a factor that we should consider. It's not akin to other legal precedents from other states, but it's a factor that I think that this commission should consider, so that we don't have a lot of discrepancies between the same company that's running and operating our businesses, which makes them perhaps less efficient and less able to more costly to do their jobs. Secondly, I don't believe that we should go beyond what PHMSA has already ordered, and they have said, in accordance to this document, that they determined it was not cost effective to require the fitting of an EFV in all existing services. Now, Commission staff, I have to confess that I feel really pretty good about the fact that they've taken this to the wall and they're very concerned about safety. I think that's a good sign from staff, and I appreciate their making that argument. I just don't believe on the record we have right here that there is sufficient evidence to agree with them in terms of this vote. So I'm going to be supporting the customer who requests it, has got to pay for it, that the cost of the device be socialized or put part of rate base. And I would, to myself, I'm not sure if it's where we are on this particular issue, but I just think that at the end of the day, once a contract has been made with a customer for X number of dollars, that we shouldn't use up more manpower, more time, more money, trying to bring down $1.58 or $112.75 from a consumer, or have to even go to litigation or court. Then we have cost collections. It just seems like to me, if the parties have come to a determination that you're going to use the last 2 years class average, and then every year you would annually update that, and then you come up with a figure that's going to be, on average, makes it so we don't have to worry about the after effects, so to speak. So that's where basically I come down on this particular issue. and I invite my fellow commissioners to ask questions or to express themselves as well. Commissioner Gray.
Thank you, Mr. Chair. I do have a few questions, and I think I agree with your position as well. My question is, how or why would a customer request an EFV if a safety inspector hasn't? Anybody help me with that concept? I mean, if I'm a residential gas user, no one's told me from a safety perspective that I should have an EFV installed. Why would I ask for one?
You don't have the authority to tell them at this point.
Okay, so if a pipeline safety inspector directs an EFV, you don't have the authority. If you had directed an installation near a residential area because of safety concerns, would this be booked as a customer cost or a utility ratepayer's cost? If you did a safety inspection and determined that it would be safer to have an EFV installed at a residence, would this be a customer paid for installation, or if a safety inspector came along and directed that it be installed, how would that then be paid for?
I don't have the authority to do that.
Okay, that helps answer. And one last question. I think, Mr. Chair, you mentioned this. Are EFVs booked as capital assets on the books of the gas companies and then depreciated?
That they're part of the cost of the service. They're in the foot of pipe that's on the books.
Okay. So I thought I heard you say that the EFV cost of the equipment is socialized, but you're talking now about the installation cost resting with the customer who made the request to have it installed, right?
I would just answer that currently the excess flow valve is built into the service T when we do a new installation, so that it's part of the capital asset for service line.
So from my understanding, clarification, now I have a customer, you have a customer who requests to have one installed. It's a residential request. If we go the direction that the resident is going to pay for that install, is that equipment that is going in the ground a part of your capital asset and on your books?
If the customer paid, there would be
The valve itself.
the valve itself is on the books.
Yes, it's
Okay,
part of the
But
capital
if the
equipment.
customer paid for it, it'd go on the books at no cost.
But the discussion is around the proposal that we would pay for the valve.
Oh, okay.
And
Sorry.
the customer pays for the installation, so yes.
That's what I'm trying to get to,
Yes.
because now you have an asset on the books, you're building depreciation around that asset, but you still own the actual equipment that has been installed based on the request of the customer.
Correct.
Okay. No further questions.
Commissioner Drexler.
I agree that the valves are a safety device, that pipeline safety is a necessity, obviously, and I do commend Chesapeake and Delmarva for their historical safety records. I think that offering this as a free upgrade or installation would create a situation where, you're probably not going to be out $138 million, but we can't guess and we can't determine what that price might be. Since it's not required, and PHMSA has recommended but required it in new and replaced distribution lines, I agree with our chairman that we don't go above and beyond that, and that a set fee for the installation makes sense rather than a true-up, because, again, then you're collecting and refunding, and it gets complicated. And I think if somebody feels that they want an EFV prior to a replacement or a new system going in, that it's for that residents to pay, or commercial client to pay.
The only comment I'd make is that I said my comments were my own personal comments, and when I referred to the true-up, that was truly my personal comments. That's my feeling that the true-up is, I think there's merit in the argument made by Delmarva Power and Light and Chesapeake that perhaps you're going to spend more money chasing the true-up than you'd actually get out of it, and therefore you'd be losing money. Now, I don't know. Maybe there's some speculation there, too. I shouldn't be doing that. So I don't want to get in the way of an agreement between the Delmarva Power and Light, Chesapeake, and the DPA on that particular issue. So if I could, Mr. Slater, do you want to comment on my comments?
I believe it's.
In other words, are we still agreed on the true up, or?
I believe I think all parties agreed to the true up. I think staff also agreed.
Okay,
Am I right?
is that right?
Really?
As a last resort.
Well, okay, I want to make a last resort motion. I move that we affirm the DPA's position with respect to who pays for the installation and who pays, the company paying for the rate-based portion, which is the personal property that goes into it. And that there be a true-up after the job is done. And am I forgetting something there? I think that's it. So
In your motion, your motion includes a true up,
it does, because
a
I think
post-installation true up.
that's what the parties have agreed to. And if the state even agrees as a last resort, I would prefer, myself, there not be a true up and they do it like PICO does it, have a contract, it's X number of dollars, the customer gets the installation, they get the EFV. If my fellow commissioners feel that's the way to do it, then we can do it that way, and we don't have to follow the settlement, but it'll be the first time in 12 years that I haven't agreed to a settlement. Yeah. So please speak up if you feel that the true up isn't necessary, and we can do it like.
I would go along with no true up with that it's not necessary. I really would. I would go
I
along with
concur.
Ray Pico. Yeah.
Okay, then I am going to change my motion to add that there will be that the companies will provide a contract with the customers to provide for the total cost of the installation plus the cost of the device, that there be no true up, and that there be no after expense go onto the books of the corporation either as a result of the contract between the company and in other words, there's not going to be anything after the fact on either side of the ledger. Is there a second to the motion?
I'll second it.
Is there any discussion, since we've been going back and forth a little bit, is there any discussion whatsoever, any question whatsoever that any commissioner has about the motion? And I will include the parties if there's some sort of a...
Yes,
Yes, sir.
Mr. Chair, but I'll yield to the party's question first.
Yes. Thank you, Commissioner Gray, and Chair and Commissioners. My question is just that when we talk about having a contract with the customer and then just sticking to that contract, from our point of view, that's the way we do contributions to the aid of construction. And what we do is before we do the work, we provide an estimate to the customer. They pay that estimate up front, and that's it. So if that's what you mean by contract, that would be how we're already doing contributions in aid of construction, and we fully support that. There was also something thrown out about coming forward with a filing that talks about average costs that everybody pays. That would be something different, but I just wanted to make sure which one we're going towards.
Yeah, it's the former and not the latter. I just mentioned the latter because it was part of the record. Someone had suggested it. It made some sense if you couldn't. Well, anyway, okay. So that's not part of the motion. Mr. Slater?
Thank
I
you.
saw that someone moved up and talked.
Yeah. So, Mr. Chair and Commissioners, my concern with not having a true up is you're going to lead to overestimating the cost to consumers. I mean, I think if we have this kind of range of where the cost is going to be, that we're going to lead to overestimating the cost, and the consumers are going to pay more. Where the true up, at least at the end of the day, we could actually true up the actual cost. Yes.
That has not been our experience, Your Honor.
Well,
Unfortunately, what happens is our estimate ends up being under, and we end up eating it.
Well, first of all, there's nothing in the record about any of this we're just talking about. This is, I mean, I understand your concern as stated, and I understand obviously how something could be underestimated as well and cost the company money. And I'm not sure over time how you'd be able to resolve that issue. I guess the safest way and the most certain way is to spend a lot of time, money, and energy with your resources and true it up to the very last penny. I mean, at the end of the day, my best judgment is that that's probably the more expensive way to do it, but I can't disagree with your opinion that it's the best way to do it either. So, but there's a motion on the table, so, and I think that Ms. Mouser may have wanted to say something, I don't want to make sure.
Well, I thought I heard a caveat that any undercollection would not be recoverable through rates by the company, and I think that is where my
correct.
concern that it would be overestimation, so that they're never in that position to not be able to recover those underestimated costs.
So
I think generally if there's...
You would rather have them be able to...
Well, that caveat is what concerned me. If they're not going to be able to recover through the rest of the customers that underestimation, they're going to have to eat that. And I just don't think that they'll be willing to do that, and it will lead to overestimation.
So you would ask that the motion be changed to let them true up if they have been underpaid.
I would prefer a true up, but if you're going to go without a true up, just the estimation, and if it's over or under, it flows through the rest of the rate class.
Mr. Chair, since we're discussing the motion before. Thank you. So as I listened to the conversation, it sounded to me as though you might need to approach this as a fixed fee proposal, and that's what the customer pays. The concern that there would be overestimating seems to me that since the customer is at the center of the payment responsibility, if overestimating is outpricing the ability to install the EVF, then customers will be discouraged from doing so. But it is on the customer to decide up front whatever that estimate is, whether they're willing to pay for it. Now, if the utility, on the other hand, underestimates out of the gate, and they learn that these underestimations are costing them money, then they'll get smarter about estimating in the future. So from my vantage point, I think that the overall implementation is going to require time for it to reconcile itself. So I tend to agree with the chair's position on the motion.
Mr. O'Brien?
If I may just clarify one thing, and it is supportive of the chair's motion, but the incentives for overestimating or underestimating, there are none anywhere. If we overestimate something, anything that comes in above what was actually spent goes to reduce rate base, which from a shareholder point of view is a no-no. That's what you don't want to do. So we're not motivated to overestimate. It's nothing that goes into our pockets. And the same is true for underestimating. When we talk about the company eating the costs, the underestimation goes to increase rate base. Now, certainly, we're not getting an immediate return on that. Nothing happens to rates because of one incident like that. But then when you get to your next rate base, your next rate case, then those underestimates or overestimates affect what your rate base is. But from a shareholder versus ratepayer perspective, I mean, nothing's being kept or eaten when we do it like we do CIACs based on an estimate.
That's not how I heard that underestimation would not be recoverable. Was how I heard, but perhaps I was wrong.
No, you've got two good ears.
Sorry, but I think what I heard was it won't be recoverable in rate base. But that doesn't mean the company doesn't get smarter about estimating future EFV installations. So
I think that Ms. Mouser makes a good point. I did make the comment that it would be no subsequent impact upon the rate base. And I think what Mr. O'Brien is saying is that the normal course of events that it would in fact flow through the rate base over or under. And would that be a true up that you would that be consistent with what you want for true up?
Yes.
Okay, so I would amend my motion to have that be the rule of this ruling as part of the customer pays for it, and that there be if it flows through to the base, over or under would flow through, and probably would be a wash or very close to a wash, and there won't be the expenditure of time, energy, and money on going after individual customers. Okay, so that's the motion. Commissioner Correa.
I have a couple of points. I do thank the staff for bringing out the point about people who can't afford will have safe service, will not have the safer service because they can't afford $1,600 to put this valve in. Is it the point you were trying to make in your memo also?
Yes, sir.
Okay, so I thank you for at least looking after the people and the group who may not be able to pay and will have to live with a safe service, and people who are able to pay will have safer one. Right. Okay, thank you for bringing that up. One question I got confused on, your one answer was that, say you bill the customer $1,500, I pay you $1,500. Who owns the equipment?
Utility.
The utility
does.
the utility continues to own the equipment, which is one of the reasons why we had suggested the statement in there about no guarantee or warranty, because there could be some confusion over who owns that equipment itself, since there was a payment being made. But definitely, just like the rest of the service line, the utility owns the equipment.
Even though you are paid for it by someone else, the utility did not pay them. You didn't pay for the equipment. I paid for it, and that as a customer, and still you own it. You will depreciate it, the labor and the equipment both. No, and it will not go into the future rate base.
Yeah, the only thing that's going to go into, the only thing that the company is, that's going to go into rate base is the EFV
Right.
and its couplings at the most.
That's correct. That's correct. When someone helps pay for the construction of a line, the payment they make
Goes for the reduction
is
of
not
cost.
in rate base. We don't get depreciation or a return on any payments made by a customer. But as far as just title ownership, that's with the utility. We have maintenance responsibilities for that equipment.
Right, but it will not go into the asset accounting or depreciation or future rate base.
That's correct.
That the chair has suggested and what have you. Is it the same thing with Delmarva also?
Yes, yes.
Same thing. Do you estimate that the difference between, say you estimate, you told me that it will cost me $1,500. I paid you $1,500. Actual cost was $1,450. So, or $1,550. So you lost $50. Do you estimate that $50 multiplied by 20,000 customers, say $1 million, will that be that big, or will that be a small amount?
In Chesapeake's opinion, if the customer is paying the installation cost, the number of requests would be relatively minimal, and that number is not going to get big.
Okay. So shareholders will eat that difference.
No.
It will go into the next year's rate base?
Right. If the actual cost was $1,550, then immediately, yes, the company is out that $50. But it goes to increased rate base, and the next time we come in for a rate case, we would be asking for recovery of that in the rate case. And then the opposite is if it's $50 less.
Understand. I think my confusion has gone out of the window.
I have a question for Ms. Scott. Are you anticipating, with these installations, charging people on a payment plan, or would it be writing a check with the contract?
I believe we're anticipating they would pay the full amount up front.
Thanks.
And I think if I could amend the motion once again, indicating that where the commission is finding that there is no unjust discrimination in our finding. Does the person who made the second agree to that change? The state has risen, the staff has raised the objection to discrimination against, and I'm just saying that I'm agreeing with the DPA that there's no unjust discrimination.
That's a second.
Is there any more discussion on the motion, which hopefully someone has written down accurately? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, everyone. Number 2 on the regular agenda is in the matter of the application of Chesapeake Utilities Corporation for approval of the issuance of company stock and long-term debt. Proposed order number 9097. Mr. O'Brien. Is any of this for you, Mr. O'Brien? Not the debt, I mean. Not the...
Thank you, Chair and Commissioners. Yes, we have reviewed the proposed order in docket number 17-0695, which is proposed order number 9097, which simply extends the 30-day requirement, which comes from the statute on the Commission's approval of requests from companies for issuances of stock or long-term debt. And the company certainly has no issue with the extension. We've discussed it with staff.
Mr. Walsh.
Thank you, Chair Winslow. Good afternoon to you and Commissioners. I was trying to rescue Mr. O'Brien from that one. I had prepared to present this. It is, as Mr. O'Brien stated, we are simply looking to extend the time and so that this matter may be heard on the 22nd. Under the statute, as you're aware, if a Section 215 application is filed and it's not approved or acted upon within 30 days, it will be deemed approved. And we simply needed more time to look at the information that Chesapeake has provided, which we believe substantiates good cause. The extension and the order merely sets that forward that it will be heard on the 22nd. And Chesapeake, again, was in agreement with extending it.
Thank you, Mr. Walsh. Mr. Slater?
We don't have any objection to this order. Thank you.
Any commissioners have any questions?
Move we adopt order number 9097 as presented.
I second.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you all. Thank you, Mr. O'Brien. Have a good day. Number 3 is in the matter of the notification of the public utility requirements for electric and natural gas vehicle charging services. And we have Mr. Walsh from staff to present this. We've received some public communications on this matter. And we may have some members of the public here today who are interested in this matter. Mr. Walsh.
Again, thank you, Chair Winslow and Commissioners. In this petition, staff is asking the Commission for an order establishing 3 things. The first is identifying owners of electric and natural gas charging facilities as a public utility. That is in accordance with the definition under Title 26, Section 102(2). Second part of that order would require those public utilities to file a CPCN, a Certificate of Public Convenience and Necessity. And third would require those public utilities to file an application for any charging rates they propose to implement. Now, that is the order we're requesting. We also request that if the Commission wishes to forego rate regulation of these public utilities, that it consider opening a docket to determine if it is appropriate to forbear from regulation, and that is in accordance with Title 26, Section 201D. And we noted in our petition that approval to not regulate would need to be done within 180 days, or it could be extended for 90 days upon showing of cause. Now, good cause. Now, the question is, why are we asking this? And I think a little bit of history is required here. On March 25th, 2017, staff forwarded to Representative Hardy and Senator McDowell package that attempted to have for consideration legislation that would eliminate several of the unnecessary regulatory requirements for public utilities, and specifically to have the electric and natural gas charging stations be exempted from the definition of public utility. There were no sponsors for that, and it was not considered by the legislature. Thereafter, less than a month ago, on July 11th, as the Commission is aware, ChargePoint was here and gave a presentation, and an impressive presentation, and demonstrated various PowerPoint pictures of their facilities and their capabilities and the types of charging facilities available. But Mr. I believe it was Mr. David Schatz was one of the presenters. He stated that Delaware is an area of regulatory uncertainty, and that they would be looking for clarification as to whether this charge point, these facilities, these various stores, entities, corporations buying and providing this electrical service for electrical vehicles would be a public utility. And we are here suggesting that the statute is clear. We reviewed the statute, which is, again, Section 102.2 states that a public utility, and this is in part, a public utility includes every individual, partnership, association, corporation that now operates or hereafter may operate for public use within this state any natural gas or electric service system, plant, or equipment. Well, if we look at that in three parts, if they have these charging stations, that entity, if it is an individual, association, or corporation, we believe there are many out there that meet that. Are they operating or hereafter may operate for public use? That's exactly what they're doing. And is it any natural gas or electric service, system, plant, or equipment? And that third prong is also met. This is not an arbitrary or capricious application. This is simply, I would say, a la Justice Scalia, strict constructionist. Do you fit into this clearly identified rubric? And they do. Anybody that has these charging stations, they're providing an electric service equipment. And if that is the case, they are a public utility. And then it naturally follows that a CPCN should be filed. And they would need to file also an application getting their rates approved. I know there have been some statements that, well, maybe they're not charging. The charging is not part of the definition here under 102. They provide this. There are fringe benefits to it. But more importantly, there are, staff is aware that post the July 11th presentation by ChargePoint, there are a lot more of these than we believed were around at first. And importantly, there are various entities with these ChargePoint facilities that are charging per kilowatt hour. Now, if that's the case, they would both fit under that definition, and in charging per kilowatt hour, it would seem an obligation of the Commission to know what those rates are and approve them. If it were 20, 30 cents per kilowatt hour, I think that would be an important factor in approving there being a public utility operating within the state of Delaware. As it stands now, it's just free-for-all out there, and that should not be the case. Now, a couple of key points, one of which I mentioned was that there are more charging stations than we had anticipated. Again, the facilities are charging. Now, all that being said, as we put in our petition, we're not trying to create a barrier to what is obviously a very good growth of much needed enterprise electric vehicles. They are, I believe the site, some of the literature out there says they're not on their way, they're here. We recognize that, and we're not trying to create a barrier to that growth. But the Delaware law states the definition, and they fall under that. So if that is the path, and that is what is submitted, then they should have notice that they need to file the same applications to be approved by the commission. And if the commission is going to forbear from regulating these charging points, or charge point and other facilities that have charge point or other types of electric vehicle or natural gas vehicle charging stations, then we would suggest that the commission open the docket and establish that as well. Those are our key points. I know that there are others here, and I would like to respond to any statements. I know there's perhaps companies, I don't know, charge points here. I know there were some other comments received. I don't know if they're on the docket properly, but.
Okay, thank you, Mr. Walsh. Ms. Ellis, are you here today?
I am.
You are coming forward with whoever you're with, if you'd like to have somebody else come forward. Introduce yourself, please.
Thank you.
And who you represent.
Good afternoon, Chairman, Commissioners. My name is Morgan Ellis. I work for the Delaware Department of Natural Resources and Environmental Control, Division of Energy and Climate. I am a climate policy analyst, but I work on a variety of clean transportation measures. I have my colleague with me, Kathy Harris, again, Division of Energy and Climate, and she works with me on deployment, electric vehicles, alternative fuel vehicles. From DNREC, we wanted to come forward and provide some comments to the Commission related to this petition. We're very interested in the deployment of electric vehicles and electric vehicle supply equipment, electric vehicle chargers, as well as other clean fueling infrastructure like natural gas. We don't want to dampen the effect of the deployment. We've been on an upward trajectory. We have a rebate program that provides rebates to Delawareans and Delaware-based businesses for the purchase of electric vehicles and electric vehicle chargers. We understand the situation where we are today. DNREC understands that. We would seek that there would be a delay in ruling on this. We would like to work with the Public Service Commission as well as stakeholders and partners to try to find a legislative action or remedy to this. We believe other states have done this where there is an exemptions for electric vehicle supply equipment and other alternative fuel vehicle fueling. We believe that we would be able to do that in concert with our partners. And so we would be seeking a delay so we could have further conversations. Again, knowing where we are today with Delaware law and what the market is demanding for supplying these vehicles with fueling. So I will put that out there. We think a CPCN process or a public utility process would, again, be cumbersome to not only the states but the companies that would come forward. So we think that there is a road that we could work on that would address this issue and seek to be in the best interest of Delaware, not only on the PSC side of things, but also on the company side.
Thank you, Ms. Ellis. I appreciate your comments. Mr. Slater, do you have any comments to make on this?
I'm going to withhold my comments for now. Thank you.
Well, I would just say that as far as I'm concerned, having been a member of the legislature before, if you've got a $400 million deficit and a lot of problems, it's not surprising that a piece of legislation or two might not get through one given legislative session. And I would not cast any blame or aspersion on any representative or any senator as a result of that. And I don't think the legislature is going to be back in session again until January. I don't know, I mean, I'm not sure why we would want to cause a disruption in the marketplace and concern all over the state over the future of electric vehicles and the infrastructure, and why the delay would not be very reasonable for us to make our pitch, and DENREC and other stakeholders make their pitch to the legislature in the beginning of this next year so that something gets done constructive to put this whole infrastructure issue in the right direction. So I am not supportive of this application by staff. And I would personally indicate that I will lobby myself in favor of some reasonable legislation like Maryland has, I believe. Other states have nearby. We do look at these other states upon occasion. But I'm not going to be supportive of this application. Any of the commissioners have any questions?
Yes, Mr. Chair, I do. I also would not favor adopting this petition at this time. I would support the delay. One question I have is, can anyone tell me what liability, penalty, or enforcement risk currently confronts any electric vehicle charging facility owner? So, for example, if you're saying by statute they require a CPCN, are they on risk during this delay period for any enforcement or penalty action?
If they are approved under their CPCN, I would believe that they're subject to the same regulation and therefore enforcement potential penalties as any other public utility. If it's specifically, if it could be a dispute, and I don't mean to sidestep the question, but it's multi-tiered between, for example, if we take ChargePoint merely as an example, and you have a convenience store chain, and some years from now you've got this convenience store chain with thousands and thousands of ChargePoint facilities. There could be, I assume, indemnification provisions in their contracts and their leases, and I don't know where the happy medium is there, but I'm sure that they have would have some indemnification provisions as to any potential liabilities.
Okay, I guess for clarification, Mr. Chair, I just want to make sure I'm not supportive of the petition, but I wanted to identify and understand whether or not during this period of delay are the persons who have not yet filed for CPCNs on risk for any penalty or enforcement actions. Can anyone address that?
If we are the ruling entity and we delay the enforcement of that part, then
the answer is no.
Yeah, that's how I would. Yep.
They're not satisfied. No further questions.
But then I'm not an attorney. Mr. Walsh.
Yeah, again, commissioners, you folks would have to impose any penalty on somebody if an action were brought. And if you're delaying it, I doubt that you'd ever impose a penalty on someone. So I don't think there's any liability risk during the delay.
Then I completely support the idea of delaying
So would I.
the action on this matter at this time.
I move that we delay the application until such time as the commission puts it back on the agenda.
Second the motion.
And Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Any abstentions? The motion carries. Thank you, everyone. Okay, we don't have anything on the hearing schedule. Is there anyone here from the public that wishes to make a public comment to the Public Service Commission? Come on now, is there somebody out there that wants to talk? We've got some members in the public. We've never had anybody from the public get up and speak, so who wants to be the first one to do it? Come on up here, come on.
First of all, welcome. I would like to make a comment. Morgan Ellis asked me to come today, and so about the electric vehicle.
What is your name, sir, please?
Introduce myself.
Please have a seat.
Yeah. My name is Mike Wall, and I'm with Clinton Electric, President Clinton Electric, and ChargePoint O&M partner for the state of Maryland, and Delaware, and Pennsylvania, and D.C. So, and also we were successful in winning the Delaware grant for the D.C. infrastructure for the 10 D.C. stations that recently went in to the Rural Farm Stores. That was in partnership with the Rural Farm Store. So one thing that I heard the staff member saying, and I apologize, I don't know your name.
Tom Walsh.
He was insinuating that ChargePoint was going to have thousands of stations in Delaware at some point, which we hope we would. But the thing is that ChargePoint doesn't own; they just sell the stations, so they're not an aggregator, as opposed to like a Chesapeake Energy that actually accumulates all that energy and sell. They're one person selling lots of energy, where ChargePoint just sells equipment and the end user. So one of the things, like we hope to promote workplace charging because a lot of people don't have chargers at home. So we hope that every workplace gets a charger for their employees, and we hope that they can pass on the cost of that charger so that the employee can bear the cost, not the company. So there would be thousands of utility companies out there then, basically, because it's not ChargePoint that would be collecting the fees. It's the owner of the equipment.
They were here a meeting or two ago and explained that to us at that time. And I think you'll find that there's probably a meeting of the minds in the room.
Yeah.
It's just that what we have to do right now is we have to work with our legislature to get them to pass some provisions in the law that are going to make it a little bit easier and beneficial to all to proceed in this area. So that's what we're really delaying for, is have the opportunity to once again talk with the legislature to change some of the laws.
So,
and of course, you probably know who your state representative, the state senator, is.
No, I don't. I'm from university. I'm from Maryland.
You're from Maryland. Okay. Well, you got a contract in Delaware. I'm sure you'll be able to find out who to contact about this issue, because that's where the real power is. We only enforce those laws that are passed by the legislature. At some point in time, as Mr. Walsh points out and staff points out, we're going to have to do something, take some action on this situation. But hopefully what's going to happen is that very reasoned and calm heads will pass some legislation, and this will be just a minor bump in the road towards successful layout of infrastructure for electric vehicles. Okay? Thank you, sir.
Thank you.
Thank you.
Mr. Howard.
Chairman Winslow, Commissioners, happy Tuesday. Let's see, opponents 2, staff 0, I believe, or something like that.
No, I don't think.
In any event.
Mr. Howard, I don't see it in that fashion. I think that staff made a good statement with respect to safety, and we just didn't agree with them on that issue in terms of who's to pay for it. We agree with them wholeheartedly with respect to safety. If they have some follow-up, we'll be happy to listen to them as well. You know, this situation here, I think, was appropriate for, obviously, the staff to push the envelope, tell the commissioners and the public that this is an issue and something we got to take care of. So I would say that the staff may not be a winner in the sense of the vote, but they were a winner in the sense of the positions they took and the fact that we need to go in the direction that they've talked to us about, which is increasing safety and also changing our laws so that we can be more efficient with respect to the layout of our electric vehicle infrastructure. So I think the staff did a very good job today.
And, Mr. Chair, if I can supplement that to our executive director, until I received the staff's petition that comes before the agenda, I was not aware that the statute required a CPCN from every charging station. So that was very helpful for me to get that perspective and context.
Well, if you also read some of the comments, you'll notice that when you pull into Starbucks and attempt to charge your phone, you should be dealing with a public utility, according to some of the comments. So, we fully understand. And I certainly appreciate the Commission's deliberations. A lot of times we push issues to the Commission because we frankly don't know what the answer is, and we certainly look to your wisdom, guidance, and counsel to point us in the right direction. So we appreciate that. One thing I did want to mention, I'm sure you're all well aware, but the Honorable Commissioner Robert Paulson was approved by the Senate at FERC as a FERC commissioner, and also Neil Chatterjee was also approved. I believe it was last Thursday. I'm always a little late to get the news, but in any event, FERC now has a quorum. So there may be some actions that will at least start up at FERC in the near future, and maybe we'll get things moving up there again as well. So I was glad to hear that.
It's interesting that Commissioner Powelson lives 2 miles from the Delaware border, so he's practically a Delawarean.
He uses the Amtrak to get to DC.
I understand he knows several Delaware commissioners.
He does. We've met him.
No ex parte, though.
Yeah, no ex parte.
Okay, the other thing I wanted to make the commissioners aware, I know it's been a long meeting and I'll try not to drag this out, but in any event, today is August the 8th, 2017. Did you know that this is National Happiness Happens Day? I wanted to make sure you are aware of that. Happiness is encouraged all day long, so I hope that you have.
I hope you would tell the rest of the world.
Now, let me make one more point. Did you know that there is a secret society of happy people?
No.
Well, my first conclusion was it really can't be secret because you Google it and it comes right up. But there is a society of happy people who their whole role is to go through life making sure everybody is happy. And in particularly on just National Happiness Happens Day. So I wanted to make you all aware of that.
Is there a local representative?
I don't.
You're a big Donald.
Yeah.
I wanted to make you aware of that because I thought it was very notable that we should be celebrating today as Happiness Day. Lastly, a couple items. We've already have our commission agenda items out there posted. Our agendas are posted on the calendar, but we will be changing the September 12th meeting to September 14th, which means we'll be moving that meeting from a Tuesday to a Thursday. And just wanted to let people, give them a heads up on that. And lastly, our next commission meeting will be held on Tuesday, August the 22nd, right here in wonderful downtown Dover, starting at 1 o'clock. Thank you.
Thank you, Mr. Howitt. The commission is adjourned. The meeting is adjourned.